Policing within the law. Learning objectives. Describe what major provisions exist in the Fourth Amendment. Summarize the basic principles underlying the stop and frisk and what differences distinguish them. Identify the circumstances in which a search is legally justified. Explain in detail when warrantless searches are justified and continues placed on circumstances. List the elements of a criminal arrest. Differentiate the four rights established in the Miranda warning. Understand when the Miranda warning must be given. Introductions. Officers need to know their own state's laws and precedent cases, as well as those emanating from the Supreme Court. Any violations of the law can result in evidence being disallowed under exclusionary rule. Basically, it means exclusionary rule, if you have violations of the law and you actually arrest someone and you've made a case, things could be thrown out within the chain of custody evidence, and without certain evidence, the person can't be convicted. Police discretion in the law. Officers use their personal judgment to choose from alternative courses of action. No liability unless evidence indicates the officer was guilty of a willful or malicious act. So when officers out there, they have to make they have to use their own judgment. Police officers need to be able to think on their feet. Oftentimes it's within a split second. You have to determine what is the best course of action. Because see, now you're talking about some things pertaining to life, liberty, and protection of property. And as long as they're doing the job, listen, sometimes police officers make mistakes. So, but as long as there is no indication that they're doing something willful or illegal, there's no consequences for that. The Fourth Amendment, constitutionally standards for searching and seizures. This is something that is very important in our country. And this is what you find in some countries, they don't have this. And this is basically to protect your rights of the civilians, people. So reasonable suspicion. You have legal standard defined as a particularized and objective basis for suspecting that a particular person stopped of criminal activity. Basis for the Terry stop requires less justification than probable cause, based on the totality of the circumstances. So reasonable suspicion is, hey, what if a police officer sees somebody, it's summertime, the guy wearing a black hoodie and blue jeans, and he's walking from a scene that you're responding to, and reports that, hey, there was someone that had a hoodie on and jeans that just robbed the place. You may have just passed him. That's reasonable suspicion, and that's how a person could be stopped. Basis for a Terry stop is, a Terry stop is what's designed is, you're not necessarily searching a person to find little stuff on them. What you're doing a Terry stop for on the side of the road is you're doing basically a pat down to find out, does this person have weapons on them? It requires less justification than probable cause. Because again, when you're patting the clothes, you're not trying to go through his pockets to find if he's got money, if he's got some drugs on him, or this and that. You're looking for weapons. And based on the totality of the circumstances, so you have to take all things into consideration. And trust me, if the person gets arrested and it goes to trial or goes before a judge, you've got to go in and articulate why you did that. So when we look at probable cause, the sum total of layers of information and the synthesis of what the police officer hear, know, observe as trained officers, reasonable grounds for assuming guilt may be based on observation by the officers, expertise of the officers, circumstance, factors, information communicated to the officers. So if a police officer is going to make it a probable cause arrest, there's things that they have to be able to justify. And it's not one thing, it's multiple things. It may be what the officer's seen. It may be based on the officer's experience, things he's seen in the past. When I've seen this in the past, this is what the outcome's been. Circumstantial factors and information that people may be conveying to them. Police-citizen contact, part one. So we look at voluntary contact. This is a request by police officers, not a demand. Like for instance, hey, can I talk to you for a minute? You know, you might say, well, no, I don't want to talk to you. And you have that right. No suspicion required and stuff. You know, I'm just trying to, the police officer just come, hey, can I ask you a few questions? Like, yeah, sure. Terry stop, the simple act of stopping someone based on reasonable suspicion. So the Terry stop again, at the end of the day, if you remember about Terry stop is about stopping someone because usually you're suspecting that they look suspicious and you're searching for weapons. Detention, when a stop based on a reasonable suspicion requires a little time to investigate the relevant suspicious circumstances. So when you have a detention, I may stop and talk to you and ask you a few questions, but I'm not going to let you go because you're being detained at that point because I suspect you may be involved in a crime. So you're not free to go. You're not under arrest. You're just detained. Seizure, whenever a police officer uses physical force or a show of authority to restrain an individual's freedom to walk away. So now when you got a seizure, this is a physical, I got my hands on you. You're not going anywhere. Search is when an officer explores an individual's clothing. Stop and frisk is not an arrest, but it is a search and seizure. So now I'm searching you for contraband, illegal, not just weapons or anything illegal. For instance, if someone had just robbed a pharmacy and had their pockets full of, and took a lot of drugs, prescription drugs. Okay, that's not a weapon right there. It's something else we're looking for. Length of detention must be reasonable. For instance, if you're going to detain somebody and tell them they're not free to leave, you can't hold them out there for 6 hours. You got some point you got to say, okay, either this person is the right person I'm looking for or they're not. And it has to be because now you've gone from a detention to actually an arrest. Use of force during detention should be minimal for safety. So you're really trying to, during a detention, rule of thumb is with a detention, use of force, you want to keep it to a minimum. One of the reasons I say that is you're not actually laying hands. You just gave them verbal commands. Plain view and plain field touch. Plain view doctrine allows the warrantless seizure and use as evidence of an object that is seen in plain view by an officer who is engaged in a lawful activity. For instance, if a police officer is standing on the street corner and you pull up in a car and you speak to him, he speaks to you. But when he looks down in your car, he sees drugs on the passenger seat. That was plain view. He wasn't, he's anybody here. See, now he's walking over to you and he may make an arrest because you have illegal drugs that he saw. A lot of times when you see this, it'll be in someone's house. They may go to someone's house or they're talking to someone about something unrelated or one thing. And while they're in there, they see a crime, they see something else in plain view. Plain touch and touch doctrine. An officer who feels or touches something suspicious during the course of a lawful activity can investigate further. So if an officer is actually saying that, a store owner says someone came into the store and stole a bunch of candy and walked out. Well, when the officer stops this suspicious person who he believes did that, and he's feeling for the candy, now he feels a gun. So and he found it because of the plain field and touch doctrine. Search is conducted with a warrant. So when you have based on warrant, these are always based on probable cause and issued by a judge. Officers prepare an affidavit, you write up all the facts and to establish probable cause. And then you go before a judge to sign an affidavit. And you swear that the facts that you put in the affidavit are fair and lawful. Now, if you lie to that judge and you shake your hand, you're subject to also some type of penalty, criminal penalty yourself. What may be seized must be specified in a warrant. Contraband, anything illegal to import, export, process. So what may be seized must be specified in a warrant. And I give you an example. If you're going in there at a drug house and a place where you suspect they're selling drugs and you find drugs, you find contraband, things to wrap the drugs in, things to store the drugs in, but then you see a very expensive TV in there, you can't take that TV. That's not in the warrant. An exclusionary rule is going to exclude that. Only things that's related to the crime. Searches conducted without a warrant. So there are ways to conduct searches without a warrant legally. One is consent. Someone to give you consent to search their house, their car, or their property, or their person. Exigent circumstances. If a police officer is walking down the street and he hears a woman holler. And when he walked past a house, he hears a woman holler, "Help, help, please don't stop." He has the right under exigent circumstances to go in up there to seek to investigate that. Now, if that means smashing a door in or smashing a glass or kicking the door in, when he heard that, he's covered because exigent circumstances. He heard someone that was actually who was stating that they were being physically harmed. Search is incidental to a lawful arrest. So you have someone who's been arrested and they actually end up, now, I've seen this before. Let's say the police officers transport this person and they take him down to the county jail. When they get to the jail says, well, we're going to search him again because before we bring him in, we want to make sure they don't bring any contraband. Well, when they do a search, it's more thorough because the person has to take off all their clothes and everything else. They find narcotics. The automobile exception. So you have the automobile exception when you have individuals that may be in an automobile, but it may not be theirs. No reasonable expectation of privacy. There are some things where you have no reasonable expectation of privacy. So when you look at, for instance, if someone goes in a phone booth, I know you don't see these, but just say that there's a booth where they can make a call, or where they can go in and make a call, or they can step behind something. Well, they're expecting the reason they went in there is because they wanted a private conversation. You can't go lean up against the glass or the door to hear what they say and then turn around and arrest them because they had a reasonable expectation of privacy. You actually invaded that, and that would not stand up in court. Lawful arrest. Arrest that the taking of a person into custody by actual restraint of the person or by his or her submission to the custody of the officer so that he or she may be held answer for a public offense before a judge. So you have 4 elements. An intent by the officer to make an arrest, authority of the arrest, seizure or restraint, and understanding by the person that he or she is being arrested. So there's things you have to take into consideration. We have lawful arrest. You know, the officer, first of all, is it a police officer? Does he have the authority? A seizure, does he have authorization for seizure or restraint? Understanding that the person, and you also want to make sure the person understands that they are being arrested. And you tell them what for. Now, talking about these arrests, this leads us to something right here that has been, as simple as it is, has been messed up so many different times. And a lot of criminals and a lot of people have gotten out of things because of it. In this country, the U.S., we have the Miranda warning. So this is something that when the officer is actually, before they place someone under arrest, they must give them this Miranda warning. And this stems from a case that goes back, I think it might have been, I'm not sure, may have transpired in California. I think the name is Ernesto Miranda. And this is where that comes from. And I think it went all the way up to the Supreme Court. Now we have the Miranda warning. So when you look at this, you have to tell them they have a right to remain silent. And realistically, when you do the Miranda warning, if you do it correctly, either you've memorized it and you have it verbatim, you can articulate it, or you read it. But if you skip stuff in there or you don't say things correctly, that actually can have this have an arrest being void. Custodial interrogation, when a suspect is under arrest, when a suspect is not under arrest, but is deprived of the freedom in a distinctive way. So custodial arrest, persons, when you've got them and you're under arrest. But here's another one that you have to be conscientious of. Let's say that you have a person and you're talking to this person and you haven't arrested them, you haven't read their Miranda rights, but they're kind of detained. But that person, you've got 8 police officers standing around them. They're not free to leave, and they can't leave. By essence of you doing that and having that many officers around, you basically just put them under arrest. Inevitable discovery doctrine holds illegal evidence obtained by admitted at trial if the prosecution can prove that the evidence would have been discovered inevitably. So when you look at this is where you may be in someone's home, police officer, and they see something. They have a warrant for drugs, but then they go into another room that they have not searched yet, and they get in there and they see counterfeit equipment to make counterfeit money and some counterfeit money in there that's not in the warrant. So what you do is you're like, okay, we were going to go in that room to search it next. And so we would have found this had we done that. So this is where that comes from. Waiving the right must be voluntary and preceded by Miranda. So if someone waives their right, their rights, you still have to give them Miranda. It must be voluntary. It must be Miranda. You can't tell them that or threaten them to get them to waive their rights, but it still must be followed by Miranda, and they must understand. So what happens a lot of times, what police officers would do now, they'll even have that person sign a waiver stating that they acknowledge it. They'll get another police officer to witness it, or they'll videotape it. That concludes this chapter.